My name is Christine Lai, and I'm the founder of Special Education Legal Fund. Today I'm here to talk to you about IDEA's legal requirements. The Individuals with Disabilities Education Act, IDEA, is one of the most powerful civil rights laws affecting children in the United States. On paper, IDEA guarantees a free and appropriate public education, individualized decision-making, meaningful parent participation, procedural safeguards, and enforceable remedies. But when families tell us that things have gone wrong in special education, the problem is rarely the absence of law. The problem is the gap between what IDEA promises and how it is implemented. Today, I want to talk about that gap and what IDEA actually requires when the system fails to meet its obligations. What does IDEA promise? IDEA is not a best effort statute. It is not aspirational. It is mandatory. IDEA requires that schools identify and evaluate students suspected of having disabilities, that schools develop an individualized education plan, or IEP, that schools deliver services reasonably calculated to ensure progress, and that schools educate students in the least restrictive environment possible. And finally, that they include parents as equal members of the IEP team. When things go wrong, it is almost always because one or more of these requirements has been compromised, not because the law is unclear, but because it has not been followed. So how does IDEA break down in practice? Let's be specific. IDEA failures often show up as inadequate evaluations or evaluations that ignore parent input, communication failures, where parents are informed after decisions are made, language access violations, including lack of interpretation or translated documents, cultural misunderstandings that can shape expectations rather than data, dismissed parent concerns despite the requirement of meaningful participation, intimidation or discouragement, which chills parental advocacy, and fear of retaliation, even though the law explicitly prohibits it. None of these are minor issues. Each represent a procedural violation, and procedural violations matter under the law, because when procedures are violated, substantive educational harm often follows. The most important thing for parents to realize is that your participation is not optional. IDEA does not treat parent involvement as a courtesy. It is a requirement. As such, parents must be notified, informed, given access to records, provided opportunities to participate meaningfully in the process, supported through interpretation and translation when needed. And when parents do not understand what is happening, when meetings are rushed, jargon heavy, or dismissive, the school district is not merely being inefficient, it is violating IDEA. But the law anticipates that things will go wrong, and that's why it includes procedural safeguards. These include the right to request additional evaluations, the right to disagree with the school's decisions, the right to written notice, the right to mediation, the right to due process, and the right to state complaints. These remedies exist not to punish schools, but to correct systems. And importantly, parents don't need to prove bad intent. They only need to show that IDEA was not followed and that the failure interfered with their child's right to FAPE. When families know the law, when they know IDEA, the conversations change. Meetings become more collaborative, or at least more accountable. Decisions are documented, timelines are respected, and concerns are taken seriously because they are grounded in the law. Your knowledge does not escalate the conflict. It clarifies responsibility. IDEA is a living obligation, but it is only as strong as its enforcement. So when things go wrong in special education, the answer is not silence. It is not endurance, and it is not withdrawal from the process. The answer is informed advocacy rooted in the law. IDEA was written to protect children who could not protect themselves and to protect families who would otherwise be excluded from decisions about their own children. If we want IDEA to work as intended, we must treat compliance not as paperwork, but as a civil rights obligation. Because when IDEA is followed, outcomes improve. Thank you.